Jaishankar. Okay, this is. Yes, yes, please. Honorable Chief Justice, Justice M. Sundar, Justice P.T. Asha, Honorable Judges, my respected seniors and members of the bar, good evening to one and all. Today we have assembled here for a function to release a book on Commercial Courts Act written by Advocate Mr. Sharath Chandran. I don't want to introduce, he is known to all our friends, our members. He is attached with senior Mr. Raghvachari's office and Mr. Lakshminarayan, well trained by the seniors. This function was originally scheduled in online some 2 weeks back. Due to connectivity issue, this was some problem happened, and now they wanted to release physically in our MBA. First, I have to welcome the Honorable Chief Justice and Honorable Judges for this function. The book will be released by Honorable Chief Justice, and first copy will be received by Honorable Justice Asha, and Justice M. Sundar going to speak on the book, and followed by reply by author Sharath Chandra. Now we are going to honor our Chief Justice. I request Mr. G. Maslamani, former President of this association, to present a shawl to Honorable Chief Justice. I request Senior Advocate Mr. M.S. Krishnan to present a book to Justice M. Sundar. I request Mr. M.S. Subramaniam to present a book to Justice Asha. With this, I welcome again the Honorable Chief Justice and Honorable Judges. I am passing the mic to Honorable Chief Justice for giving a presidential address. Book release and presidential address. This is the book will release. few words, Lordship. You come this side. I will open. Packed it.
Packed it quite well.
Fully packed.
Packed in such a manner that it may not be released.
They have to say that it's part of my senior, right? Labor of love.
You have to receive it. Yes, Lordship, please.
Yeah, that is what the order is.
Yes. Okay. Okay. Now we are going to speak. Yes. I request Justice M. Sundar to address the gathering. Please.
I'll go that side, Chief. I'll go that side. Okay. Thank you. Honorable Chief Justice, all the other honorable judges who have taken time off this evening, members of the bar, office bearers of the Madras Bar Association, author of the book, Mr. Sharath Chandran. I think somebody from the publishing house is also here. A very good evening. On this book on Commercial Courts Act, I had the privilege of writing the second foreword for the first edition. That was barely 1 year and 2 months ago. And the first foreword was written by Justice Rohinton, as you would see. I never thought I would be so prophetic when I said this book will see many more editions very quickly, but never did I think it would be so quick. So many congratulations. That is the proof of the pudding is in the eating, and that applies to a book too. Normally they say don't judge a book by the wrapper, but here the book here does convey a message in terms of the wrapper also. That's why I carried the first edition. This is the second edition that has been released today by Honorable Chief Justice. The first edition, if you see, this is the Guildhall, London, where Lord Mansfield sat and did all the commercial matters. And Guildhall is where the merchants meet, and that is how the law evolved. And this is the second edition which has come 1 year, 2 months later. And this is our own Rajamannar Hall. So therefore, I feel the book conveys the message, and I'm sure we are living up to that. We are definitely living up to that. The reason is this. Please see the statistics. I'm not going to go only on numbers. The rate of disposal has been far more than that of the rate of institution in the Madras High Court, which has been one of its kind pan-India as far as the commercial division is concerned. Therefore, we've been doing very well in terms of disposal. It's all there in the... And number two is, please see the number of case laws. May be reported, may not be reported. That is another very good aspect of this book. Even those of the case laws and orders which have not been reported have been meticulously looked into and incorporated. And how well incorporated is, different views are emerging because this is a new act. For instance, the classic, I'm not going to take much time only on this. All of us are aware. Just to highlight, I'm saying this, all of us are aware, this is a very, very learned gathering. For instance, 12 capital A of the Commercial Courts Act, pre-institution mediation or the pre-suit mediation, whether it is mandatory or directory, has been a vexed question, and different high courts have taken different views. All that has been very nicely collated, and the different views have been given together. One high court has gone as far as striking off the plaint. Another high court has said it is directory. All that has been captured here. And Ultimately, the matter is pending in Supreme Court. That has also been done. That has also been captured. It has been very, very meticulously done. The other USP, because it's commercials, I thought I should use the term. We are in commercial courts. I thought I should use, with the permission of the publisher, if they are here. The other USP of this book, besides this, is, to my mind, in my humble opinion, this is the only book which captures the trajectory which the commercial court, starting from law merchants in London, has taken. He's taken, it comes naturally to him. Therefore, he has captured that very nicely, and chapter 1 is very, very critical. If you go through that, you will get an idea of how the law has evolved and why a separate law is required. And just two more aspects and I will conclude. This Commercial Courts Act is only a procedural piece of legislation. It is not substantive act. At the end of the day, it is amendments to CPC. CPC consists of 158 sections, 52 orders and 8 appendices, as all of us know. And out of this 158 sections, 52 orders and 8 appendices, 3 sections, 10 orders and 1 appendix has been added to the 8 appendices. That's all. That is the soul of the statute. But the statute gains immense significance in terms of a policy, and therefore it is, you see the kind of case law that is evolving. In a procedural law, in a procedural piece of statute, so much of case law is evolving. And the most important and interesting aspect of it is the IPR, which gets swept into the commercial division because of 21C17, read with the first proviso to section 7, and been advocating that there should be an equal proviso to 6 also. That's a different matter altogether. We will have that for a discussion separately. One last word about the author. I am not saying this ceremonially. I am not saying this because I've been asked to be here. I'm saying this with all sincerity at my command. He is an Oxonian. And whenever I go to Oxford, I make it a point to go to the Rhodes House and look at the list of Rhodes scholars. The reason why I do it is, I try to look up the number of Indian names there and people from this part of the world who went there and became Rhodes scholars. Generally, Rhodes scholar is, you know where the rating is. Here, the first foreword for the first edition has been written by Justice Rowington, and he calls the work a scholarly work and compares the author with Sir Dinsha Mullah. Therefore, I am not saying this. I am only saying what the Honorable former Judge of the Supreme Court has said in his first foreword to the first edition. So therefore, it is as good as becoming a Rhodes scholar, coming from whom it has come from and what he has said. He says it's a scholarly work. Therefore, being an Oxonian, maybe he is, that is his moment in life and career as far as the book is concerned. And I'm sure it also has a very, very practical utility value, because the entire timelines has been put in the form of a table, which has been very nicely done. I compared it with the provisions, and to the best of my reading, I find it to be accurate and having lot of clarity and specificity. This clarity and specificity with which the table and the timelines have been captured will serve as a bench book also, very quickly for anyone to look up the timelines. Therefore, with these words, I wish the author very well. I wish the publishers see many more editions, and not just reprints, many more editions, reprints also, because it's commercials, again part of your commercials. But that's the reprints part of it. The editions is the academic part of it. So I wish both the author and the publisher very well, and and thank you very much for the opportunity to be here with you. Thank you very much. Yes, yes, Chief has to speak. Yes. Should I, Chief? Sorry, Chief.
Yes, Lord, please. I request Honorable Chief Justice to say.
My esteemed sister and brother judges, senior advocates, members of bar, media, the writer of book, Shri Chandran, publishers. The program was organized to release the book on a virtual mode, but it was designed to have it on a physical mode, and the day was also designed. Today we have inaugurated or released the book, physical mode. I have gone through the book, and before that, why commercial court at all were required. This was taken up by the government of India that a development of the country that may stuck if the litigation remain pending, and that too for the years together. On the commercial side, you need to have expeditious disposal of the cases, and therefore almost 7 years back the Commercial Court Act was brought. This again, my brother said, that is basically a procedural law and part of CPC, but to make it little easy, less complicated, to have expeditious disposal of the cases by creation of new courts, that is the commercial courts. The challenges always comes whenever there is a new legislation, the interpretation of certain provisions, the framework, and again conflicting judgment at times on same issue. As brother was saying that different high courts have taken different view. That needs to be compiled. The book is required to be updated, and I find this book written by Sri Chandran is a complete code for a lawyer practicing the commercial court side. Nothing else is required to be referred. He has covered all the issues in different chapters, and the judgments, whatever has been given, like I was going through a judgment written by my brother regarding the execution of the order passed by the commercial court. The conflict was whether it can be by the normal process, that is by the civil courts, or it has to be by the commercial courts. The judgment of other high courts were there, but our high court has also taken the view that it should be by the commercial court itself. These are developing features of the legislation that is required to be compiled. So what my brother said, just Sundar, that the second edition has come very early. I would say that this shows the growth of the law which is required to compile, and we have to come. And Sri Chandra has rightly come out with the second edition very quickly. Because if you compare from first edition to second edition, you'll find a lot of changes, lot of developments in terms of the interpretation of the law, the judgment of different high courts, and that has been compiled so that anyone practicing his side can go through the judgment and take the proper plea in reference to a judgment either of the high court, though I mean many of the judgment I have seen referring to one and same issue, conflicting judgment of different high courts. The matters are definitely pending, and the final word would come from the Supreme Court, but at this stage also the compilation of those judgments have been given, and apart from that the interpretation of every provision has been taken with very minute examination. Anyone who wants to prepare a case for the commercial court can rely on this book, because interpretation that can frame your arguments, frame your case laws, frame your case itself. So I extend my hearty congratulations not only the writer but the publisher for coming out with the second edition. It is, again, I've seen the certain provision of the law and the interpretation given therein, different chapters. The time will not permit to take up all the issues which has been narrated by him, dividing in different parts beautifully, making it easy for the reader to take note of. And I can say it has been taken out in such a manner that is not only for the lawyer but even for the litigant, because commercial court litigant generally considered to be different than other litigants. They may go very deep on the issue, and even coming to the lawyers, they may go through the book also to know what are the provisions, how his case is going to be taken up. For them also it is very easy to know what is the law, what is the provision, and how the case can be taken up, how it can be given shape. So this is not only covering the advocates but even to the benefit of the litigants, that is very easy for them to know about the provisions of law. And lastly, even for the courts, I say is a definitely gift to the courts. The time constraint everybody knows that remains with the court, and whenever they want to make a research, assistance is provided. But if the compilation of book is in such a beautiful manner, it becomes very easy to know about the provision, the interpretation, and which way the issue is to be and what manner it has to be decided. So whatever labor you have put in is all goes to your credit, because with the first edition you come out immediately with the second edition because of the growth of the law, the interpretation,